All right, welcome to today's meeting of the Senate Senate Judiciary Committee. Let's go ahead and call the roll.
Senator Kriegel,
Here.
Senator Crum,
Excused.
Senator Hicks,
Excused.
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
All right, we have, our committee is filling up with bills. We have bills coming out of our ears, so we're gonna start meeting a little more regularly than we're traditionally scheduled, just so the public knows to watch for that. We will start using Mondays, Wednesdays, and Fridays as well to try to get through these bills. We have also kind of aggressively scheduled 4 bills today. I'm very optimistic about that, so we'll see how it goes. So that's just to the public, just try to be as succinct as possible and not repetitive, and that will help us do our work. So the first bill we have is one that we're continuing over from our previous meeting, and that's Senate File 9, Restoration of Rights Amendments. We took testimony on this bill already, but would welcome any additional testimony if there is any in the room. I don't think so. And Director Shannon, we got your email. We also had staff prepare an amendment, so we've got both. I think trying to tackle the same exact issue. So we are aware of that. Is there any public testimony online? No, all right, well, we will close public testimony. Welcome, Senator Crum.
Thank you, sir.
That was speedy, you did good. All right, Senate File 9 is in front of you. Committee, what is your pleasure?
Move the bill, Mr. Chairman.
Okay, it has been moved. Members, I emailed you an amendment. I'm sorry I don't have a copy of it, but I did email it to staff with hopes that staff would catch that and maybe print it. Oh, I sent it to Judiciary Senate staff, so it went to all staff. Maybe you're not on the list. Oh, you see it? Okay. Can you print that for us real quick? Okay. So while we're getting that printed so we can all have it in front of us, a couple of things about the amendment. First is that it comes from a staff comment that was in the draft legislation of Senate File 9 during the interim. So for those of you that are new to the committee, you're seeing it for the first time. For the only one who's returning to the committee, Senator Kriegel has seen this amendment before. I can't speak for the entire committee, but I think at least from the comments that I received and the input from this committee, I think that this amendment more closely aligns with what this committee wants to do as it relates to restoration of firearm rights, possession of a firearm. And there was something else. What's the second half of what this amendment does? There were 2 things. Senator Kriegel?
Thank you, Mr. Chairman. Essentially, it addresses the issue we talked about where we will still be able to allow restoration of rights for voting purposes for out-of-state convictions, but the restoration of rights will not apply to the firearms part. And talking to the good director, I think that's doable, and so we're just putting that language back in that was taken out in the current bill draft, and yeah, it just separates out subsection F into its own part and parcel of the bill draft.
Yeah, and Director Shannon, the amendment you sent us addressed, it looked like it did a good job addressing the out-of-staters, but wasn't as clear with possession of a firearm. So I think that wasn't, we're explicitly spelling that out in this amendment. And here we go. So the amendment takes place, you can see the red language down at the bottom. That's taking place on page 7 and page 8. We're deleting the subsection J, or subsections H and J, right? 7:18 through 23. No, I'm sorry. We're just deleting subsection J so that it would read, a person shall only be eligible for a certificate of restoration of rights under this section as follows, and then insert the red language at the bottom of the amendment. Under subsection A, that's the governor's certificate of this section, if the person was convicted of a felony under the laws of the state of Wyoming or another state. So there's that first part. And then the second part here is for purposes of the restoration of rights to possess a firearm under subsection F of this section, if the person was convicted of a nonviolent felony or nonviolent felonies arising out of the same occurrence or related course of events under the laws of the state of Wyoming. And then there's a third prong that says under subsection B and C of this section, if the person was convicted of a nonviolent felony or nonviolent felonies arising out of the same occurrence, related occurrence of events under the laws of the state of Wyoming or another state. So that's the amendment, folks. I guess we've talked about it before moving it, so if somebody wouldn't mind moving it. Okay, it's been moved by Senator Kolb and seconded by Senator Crago. Any other discussion on this amendment?
Chairman,
Yes, Senator Hicks.
and maybe the Senator Crago may be able to answer this question in the interim. So what I'm curious is did we do any look to see whether what we call out as nonviolent felonies are consistent with other states? In other words, each state has the ability to kind of address those. You know, I know NCLS and some of those organizations will actually do those comparative analysis. But did the committee look at that to see if our other states' laws are similar or consistent with our laws, what we define as nonviolent felonies?
Senator Crago, do you recall?
Mr. Chairman, Senator Hicks, we did not delve into that. So the department has, when they start doing these restorations of rights, I believe they have to look into that and verify that they are similar to ours in nature. But we did not do it as a committee. That falls on the department to do when an application comes in.
So is nonviolent, there's not a reference to a statute, so there's not, so there's not a list of felonies that are statutorily defined, or is there?
There is within the statute, it's just not in the bill draft.
Okay. Yeah, it just says, maybe this could have been worded differently in the bill, but it says nonviolent felonies under the laws of the state of Wyoming versus nonviolent felonies as defined in such and such.
Mr. Chairman, if you go to page 5 of the bill, it defines a violent felony. And it says means as defined as in Wyoming statute 61104A12. And then it says nonviolent felony includes all felony offenses not otherwise defined as violent felony. So we do it by reverse
Okay.
definition.
That answers my question now. Thank you, Senator Crago. Any other discussion on this amendment? All those in favor of the amendment of amendment 1 to Senate File 9 signify by saying aye.
Aye.
Any opposed? Okay, that amendment does carry. Are there any other amendments to this Senate file? Any discussion? Ready to vote? Pierre, will you do a roll call vote on Senate File 9?
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
No.
Senator Kolb,
Aye.
Chairman Olson,
Aye.
4 ayes, 1 no.
Mr. Chairman,
Senator Hicks,
if I may, I would like to explain my no vote.
go ahead.
And it revolves around this issue of what states call nonviolent felonies. And what we've seen when I go back to the 3 or 4 years ago with all the pandemics and riots and stuff. And we're continuing to see some states change the penal code to the point that almost everybody is no longer a violent felon. And I'm really concerned that by doing this, we may open that floodgate for something that not consistent with the laws of the state of Wyoming by maybe a left or a right coast state under the provisions of this. And so that's my concern, Mr. President, and that's my only concern.
Director, did you have some comments on that for us?
Mr. Chairman, committee members, I'm Dan Shannon with the Department of Corrections. Senator Hicks, I appreciate your concern and your question. That is an operational method. We don't, at the Department of Corrections, take that upon ourselves. So the example would be if a person has a comparative that we're unsure of in the state of Oklahoma, that goes to our AG's office. They contact the AG's office in there and do a legal comparison on the crime. I'm not sitting there saying, well, this is a different offense and I want to read the pre-sentence investigation. That's the length that we go through. But when we come down to it, we have a legal review. We're not just arbitrarily comparing codes or numbers to see if they're comparative or not.
Senator Hicks?
Mr. Chairman, so that begs the question is the way the statutes reads, where would the Attorney General's office get the discretion to say, well, it's not consistent? Because I don't see that language in there. So I would love to have some discretion to look and make sure it's consistent with ours, but I don't, maybe we can do that in an amendment, but that is my very concern, is as we've said, no, as long as another state defines it as a nonviolent felony, I don't see where the discretion the AGs reviewing these would have to come back and direct the department under a discretionary analysis to say, no, you can't do this.
Certainly.
Director Shannon?
Yep, Mr. Chairman, Senator Hicks, under the work done by the interim committee, as well as my understanding of the amendment, it wouldn't have any effect, because if they were from out of state, they wouldn't be issued their rights, their gun rights in Wyoming,
Okay, all right,
if that helps you.
thank you.
Mr. Chairman, Senator Hicks, as you may be aware, we've had a number of cases, approximately 63, that had felony convictions in the U.S. Federal system, that we issued certificates, and that's why we requested the interim topic, because if it's not a Wyoming case, we're not reissuing. That's what the request is, not to reissue gun rights if it's not a Wyoming case. I hope that answers your question.
All right, thank you, that clarification.
Senator Craigo, would you mind for managing this? Since it's the last interim bill we have, and I hate to give you more, but you're the only one that was there during the interim, so.
Yes, sir, happy to do
It's
so.
punishment for being on the same committee
Yep,
twice.
yep, thank you.
Don't ever do that. That's why I bounce around, from committee to committee, and I don't have to do all the work. All right. Next, we have Senate File 104, probate code revisions. Senator Craigo. The floor is yours.
Yes, thank you, Mr. Chairman. Barry Craigo, Senate District 22, which I'm gonna have to practice not saying House District something or another, because you get in the habit of doing that. So thank you, Mr. Chairman, committee members. Today I bring to you Senate File 104, probate code revisions. And to be honest, this is a bit of a constituent bill. It came to me from some of our friends in the legal profession. Currently, our small estate probate number is set at 200,000, and it's in several places in statute, so that's why this bill draft's a little bit longer, but we're just changing that number under the proposed bill draft from 200,000 to 500,000. And really, what this is gonna do is help a lot of our constituents back home, ease the probate procedure for them, so they can go through the summary procedure versus the long drawn-out probate procedure. Which I do a lot of those, and so I know how much time those take and how this will help a lot of our folks and families dealing with estates after their loved ones are gone. And so it's pretty simple, pretty straightforward. There's one part within the bill, and I'll just walk you through the bill real quick and get to the part that I do need to explain. So on page 2, we're just changing the 200,000 to 500,000. Page 3, that's the only addition on page 3. our change would be from 200 to 500. Top of page 4, same thing. And then on page 4, there is some language regarding disclaimers, which is above my pay grade, but I'll do my best to explain it. It's kind of a complicated issue for a lot of lawyers that deal with advanced estate planning, and some that dabble in it, like myself. What this has to do with, it's giving our local lawyers and our local constituents more flexibility in their estate planning regarding disclaimers after a loved one has passed away. They may want to disclaim that property for federal purposes, for tax purposes. But under that, there's a time frame by which they must do that, which is 9 months. This is saying that for state purposes, they can disclaim after that, because right now under statute, they have to do it in accordance with the federal law. This is giving us some more flexibility on the timing of that. I think that's the kind of the layman's version. We'll have some testimony that's a little bit better than mine in explaining it from some of the folks that deal with trusts and estates a lot more than I do. And then on page 5, again, we're changing the 200 to 500, and these are just spread out through the probate code. Page 6, same thing for non-resident property. We're changing it from 200 to 500, and it's stand for any questions. I think if they get too in-depth, we'll defer to some of our experts.
Questions for, yeah, Senator Kolb?
Thank you, Mr. Chairman. Senator Craigo, I guess a background on when the last time they changed this from 200,000 and now why is $500,000 the right number? I guess, how did that come to be? Thank you.
Senator Craigo?
Yes. Thank you, Mr. Chairman, Senator Kolb. So this was last changed in 2011, and it was changed from 150 to 200. I think the impetus now, and I'm not promising you that 500 is the right number. That's just a number I picked because I think it's one we should have a policy discussion about. But really what this is about is when we do probates, the one piece of property that most folks have is a home. And in the last 5 years, the value of everybody's homes in Wyoming has doubled at least. And so my idea was to at least double that and probably build us in a little bit of room for inflation. So if we went from 200 to 400, give us a little bit of inflation room so that we're not doing this again in 2, 3, or 4 years. And that was really why I picked that number, Senator. If you thought a number less than that is more suitable, I am open for suggestions. But it's not based on science or anything like that. It's just based on the fact of how much homes have gone up in price and value.
Senator Kolb?
Thank you, Mr. Chairman. And to that end, if the subject is really home value, obviously it would seem 500 seems low. And I guess the question would be is, what number is a good number? Because I don't see any inflationary buffer in here. It seems like we're kind of shooting a little low. If that's the reason for this, is really driven by a probate because of a residence, and so I guess I'm open to listening. Maybe if you had a thought about another number, or if you still are happy with 500. Thank you, Mr. Chairman.
Senator Craigo?
Thank you, Mr. Chairman. No, I think 500 is a reasonable number. I think there's more stakeholders than just our constituents and the folks dealing from the legal side of it. We have bankers involved. We have other entities that may have some say in that. And in talking to folks, this is kind of a number that everybody thinks is a reasonable adjustment.
Mr. Chairman,
Senator Crum?
question I have is, along the line of Senator Kolb's is, what about inflation? Would there be ability to tie some sort of inflationary adjuster to this where we're not having to come back in 10 years and say, well, it's too low and that type of thing?
Senator Craigo?
Senator Crum, Mr. Chairman, through you. Actually, lawyers can't do math very well. And so I'd just assume we keep a number in there that's steady. And if 5 years or 10 years from now, we need to change it, so be it. But it gets really complicated. So, if I have to go look every time and do the math every time I file a new probate, it's just, I think the lawyers would prefer, personally speaking as one, that we just pick a number and leave it there.
Thank you.
Senator Craigo, excuse me, I co-sponsored this bill and just wanted to, I think comment a little on the 500,000, and I think you're spot on, the reasoning behind it for the house. I do some probate work, but I mostly do estate planning, so I do the other side of it. And anymore, it's gotten to the point that 99% of people who come into my office, I have to recommend a living trust for them, because if they have more than $200,000, they go to probate, and anybody with a house goes to probate. But if that's their main asset, and maybe they have a few here and there ancillary things, it may be a lot of work to put together a trust for them. So I think that from the estate planning perspective, this is going to help a lot of people as well, that don't necessarily need to fall into that trust realm, but can still get by with a simple will.
That's exactly right. Thank you for the help, Mr. Chairman.
Any other questions for Senator Craigo? All right, thank you. Already lined up for public testimony. This is helping my meeting move along quickly. I appreciate that.
Maybe not. Oh, good afternoon, Chairman Olson. I'm sorry I jumped the gun a little coming to the
No, it's
desk
perfect.
early. Well, my name's Kristen Lee. Good afternoon, Senators. I represent the Wyoming Trust Association. And today with me, I have at my left, Darcy Barber, who is the Senior Vice President and Trust Officer at Wyoming Bank and Trust, and also a member of the Wyoming Trust Association. Online, we have Ms. Jordan Chandler, who is the president this year of the Wyoming Trust Association. And I'd like to turn it over to Ms. Chandler, and she'll give you a brief perspective from the Wyoming Trust Association.
All right, can we admit her? All right, is Ms. Chandler? Go ahead and just, introduce yourself to us and then let us know what you want us to hear.
Good afternoon, Mr. Chairman and committee members. My name is Jordan Chandler. And on behalf of the Wyoming Trust Association, we really appreciate your time today in considering Senate File 104. Senate File 104 proposes to raise the probate limit from $200,000 to $500,000. As Senator Craigo mentioned, the last time this limit was raised was in 2011, when it was raised from $150,000 to $200,000. We are asking for this most recent change due to inflation, especially in housing prices since 2011, has caused situations where estates above $200,000 must go through probate according to existing law. As an example, a person who does not leave their house to a surviving spouse, or a single person who owns their home, dies. Houses are now worth more than $200,000, and if the estate has a car or other real or personal property, the estate cannot use the summary probate process to easily deal with the assets and must involve the court. Raising the statutory amount to $500,000 will be better for families and their heirs to avoid the cost of lawyers and time involving a court. Raising the limit will be less expensive and more efficient for dealing with assets and estates under this $500,000 limit. Under current law, at the $200,000 limit, notice is provided to creditors, and creditors have the opportunity to open a formal probate to have their issues addressed. Raising this amount to $500,000 will not affect the existing rights of creditors. Creditors will be notified the same. Creditors will have the same right to prove their claims. We are not asking to change any of the existing process or procedure, which will affect creditor rights with the change that we would like to make to the current limit. We ask for your support of this change. I will stand for any questions. Thank you.
Questions for Ms. Chandler? All right, thank you, Ms. Chandler. Appreciate you tuning in with us. Back to the room here.
Mr. Chairman, we have nothing further. Thank you very much.
All right. Any, no questions, committee? Okay, thank you. Anyone else in the room wishing to testify on this bill? Mr. Meyer?
Good afternoon, Mr. Chairman, members of the committee. Scott Meyer on behalf of the Wyoming Bankers Association. in part, and in part, I'm kind of a little bit conflicted because I'm also a practicing attorney that does estate planning and probates and have for almost 30 years in Cheyenne and Lander. I think that I think that the idea that moving that up to $500,000 makes a lot of sense for all the reasons that were testified earlier. But keep in mind that that's probably going to be half the probates in this state. The question then is, well, why don't you make it $1 million? We'll get rid of almost all the probates. And the reason that you don't do that is because of the fact that there are creditors. When you do this and you do a simple type of probate under 201, you could talk about 204 and making notice there, but you could do it under 201. You find out that in those cases, creditors have been left high and dry, only because they can get notice, but they have to wait 90 days before they do what they do. Whereas somebody just filing that affidavit of summary distribution under 201 waits 30 days. So if Uncle Joe passes away and you've lent money, you may be out cold because somebody's already taken the money from a financial institution or somebody else that has it. When it was back at 70,000 when I first started practicing law, it was not a lot of big deals. When it went up to 150, you started going, okay, maybe there's a little bit of a risk here. 200, maybe a little bit more. Moving up to 500, there could be some more risk. And that's the risk that I think that we need to kind of pay attention to. You look at it and you say, here's what's out there. But really, when you think about that risk, what risk is it? What we find, what I've found over the course of my practice is that when it was at 150 or even 200, you say, great, there was $25,000 in the bank account. We did a summary distribution that went out, and we've now stiffed a credit card company. We've now stiffed somebody else. Usually not that high, but you let them know that there was not enough to have an actual probate. They certainly have the right to open a probate if they want. Nobody's going to do that for that kind of money. For $500,000, maybe. But the reality is, I don't represent all those creditors. I represent banks. And when you look at it, what creditor is going to lend that kind of money unsecured? The only three areas that I can think of that might have something to do that is if you had a really high limit on a credit card, which I haven't seen anything over 25, so I'm not sure you're going to get anything big. But the two areas I look at are co-ops. If you look in like the Bighorn Basin, you look over in Goshen County, agriculture, they have co-ops, and those are unsecured usually. And so they might run those bills up. The other is healthcare, whether it's the hospital or the nursing home. They may have some kind of things, but they're the ones that are coming back looking for their hands out. If you had some money that got out of there, there might be some reason to claw that back. In my conversations with practicing attorneys as well as my members, we don't see that as a problem, except for the fact that the idea that I got and what I want to submit to you folks is that this is putting a Band-Aid on a compound fracture. We like the idea, it does help, but somebody needs to seriously consider maybe doing an interim study and revising the probate code. There's a lot of stuff in here that this is not going to address or fix, and part of that's with the creditors. But I think it is something that's probably worthwhile. You know, when I first started practicing law, some people brought up the Uniform Probate Code, maybe we ought to look at that. And then you had very senior lawyers that said, not under my watch. Most of those guys are gone now. Maybe it's time to look at something. I'm certainly not advocating for it, but because of these issues, because of the $500,000 and what you do with creditors, that may be something to consider. Other than that, the Wyoming Bankers Association and its members support this change, and I'd stand for any questions.
Senator Craigo.
Thank you, Mr. Chairman, Mr. Meyer. So just to clarify, are you comfortable with the $500,000 figure, or would you rather it be, would your membership rather it be something else?
Mr. Chairman, Senator Craigo, I think my members are happy with the 500,000. The reality is when you look at it, you're not going to see too many people getting very high without having some security from a bank anyway. So I don't think that they have a lot of concern that it's going to go up to 500. those banks that do have the trust departments, we understand how much easier this will be for their lives.
Very good. Senator Crum.
Mr. Meyer, would it be fair to say that if a bank had a unsecured line for 500,000, they're probably able to find out about that borrower if he ended up passing away, they would know that he passed away if they had a $500,000 line?
Mr. Meyer?
Mr. Chairman, Senator Crum, I think that's a fair assessment. If you had that kind of line out there, somebody's gonna be paying attention to it.
Other questions for Mr. Meyer? All right, thank you, Mr. Meyer.
Thank you.
And we will seriously consider interim topic on probate code. I would be very interested in that.
Move the bill.
Okay, was there any other public comment? All right, back, closing public comment, Senator Hicks moved the bill. Any discussion on this bill? Amendments on this bill? Pierre, will you do a roll call vote on Senate File 104?
Senator Craigo,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson.
Aye.
5 ayes.
Chairman,
Yes, Senator Hicks.
could we have staff just kind of start keeping a tally of potential interim topics as we go through here? My experience is if we don't do that,
We'll forget about it.
In 5 weeks from now. And I was just sitting through this is like, I was actually on Judiciary Committee in 2011 when we took this up, and Chairman Perkins at the time kind of led that effort, so it's been a while.
Okay. Pierre, you got that? Probate code revisions? All right. No, we're not gonna talk about that. No, thank you. All right, the next bill for our consideration is Senate File 10, Settlement Agreements for Minors Parental Authorization. Oh, I thought we were through the joint bills. I guess we have one more joint bill. Craigo will carry his own bill. Senator Craigo, do you have recollection to walk us through this one?
I do.
Okay.
All right, thank you, Mr. Chairman. Barry Craigo, Senate District 22, appearing before you as a member of the former and current Judiciary Committee. This was actually a bill that I ran as a personal bill last year. We just ran out of time to deal with it, actually. And this is also another constituent bill, and really it's just trying to catch us up with inflation and where we are in today's world. And essentially what this does is raises the dollar figure before a judge has to actually approve a settlement agreement for a minor. And so if we start on page 2, get into the meat of the bill, we're raising it on a conservatorship from $5,000 to $25,000. Moving on down, and that's in Title III. And so these are all related actions that would happen. For example, if a minor let's take for example, gets in a car accident and they're entitled to a settlement from an insurance company. Well, under current law, if that settlement is more than $5,000, if it's more than $3,000 on a case, then it has to be approved by a judge. That has to go before the court, and it's just slowing down a lot of the resolutions of cases. And so some of the lawyers reached out to me and asked me if we could deal with this particular issue. So if it's a small case, small amount of injury, that we can do it without burdening the courts with filings, court time, etc. And so moving down on page 2 in Title 14, this is the language regarding the settlements, which raises that to $25,000 from its current amount of $3,000, which $3,000 would literally, there are no cases below the $3,000 mark. And even at $25,000, most of your personal injury cases are going to be above that. So the judge is gonna see most of them. This is just gonna be the minor ones, and that's really what we're talking about. Moving on down on page 3, this is some addition, this is all new language. And it really just sets forth the boundaries that we're putting on the parents or the guardians of the children. And that they essentially, they are not allowed to, if they take the money, they're not allowed to use it for their own personal good, that it must be set aside for the children. And that's really what the court order does now anyways. And so this is just saying that, hey, if you're gonna use this process, that these are the sideboards, this is what it does. And so if you have any specific questions about those particular sideboards, please shoot them my way.
Mr. Chairman,
Senator Crum.
my question on this is, let's say any reasonable person, a settlement should be, just make up something, $100,000. But due to the parent needing money, maybe a drug habit or something like that, that they say, okay, I'm gonna use this provision and settle for $25,000. What keeps that from happening? Because, I could see that happening in certain situations.
Senator Craigo?
I guess I'm a little unclear on your question, Mr. Chairman. So if it's below the 25,000 or above the 25,000?
So the question be, a reasonable person would say the settlement should be in $100,000. But due to the parent or guardian's situation, maybe a drug problem, they say, I can get $25,000 right now. I don't have to go through court proceedings and wait. I really need my fix or whatever. So I'm gonna settle for $25K. And therefore the child doesn't get the additional funds.
Yep, so if you turn to the last page, or second to last page, Senator Crum, through you, Mr. Chairman, there is a provision in here that would allow the minor to bring a cause of action against their parent or guardian if they unlawfully or entered into one of those agreements, which to not to the benefit of their child, essentially is what that language says.
Thank you.
Other questions for Representative Craigo? All right. Thank you, Senator Craigo.
Mr. Chairman, I would just, if
Was
I
there
might-
more?
Well, no, there's not. I just wanted to make one comment that mostly what we're just trying to do is reduce some regulation, make it easier for folks to conduct, especially our lawyers who are representing these kids and the families, and make it easier for them to do their jobs. But at the same time, put a few sideboards in there that did not exist before, so that, to your point, Senator Crum, that there is some protections for the kids built in.
So I'm gonna ask the Senator Kolb question then. So, yeah, what was the science behind 25,000, or was it not scientific?
It is, Mr. Chairman, it is not scientific. That was the number that was requested by some of our good trial lawyers around the state. That was the number they thought was reasonable, because there is some liability, right? I mean, they don't want the number to be $100,000 either. At some point, they want the judge involved in that decision. And so that was sort of the number they thought was a reasonable number based on their claims, what they do on a daily basis. Now, I'm sure there's a realm in there where we could raise it a little. I don't think we'd want to go down any, but I think there's some band in there where if you said maybe 30 or 35, so be it, but it's not scientific. It was just, that's what they felt comfortable with as the practicing attorneys.
All right. Thank you, Senator Craigo. Public comment in the room? Yes, please come forward.
Good afternoon, Mr. Chairman, members of the committee. My name is Mark Aronowitz. I'm a practicing attorney. I am the Director of Lawyers and Advocates for Wyoming, a public interest not-for-profit law firm. And I'm Secretary Treasurer of Wyoming Trial Lawyers Association right now, so happy to speak for both entities. So as a practitioner, this is a helpful and important bill. Sometimes when you put a specific monetary amount into statute, like $5,000, and years or decades pass, if you index for inflation, this probably would be about $25,000 now from when it was first put in. And the $5,000 amount can be pretty cumbersome when you're dealing with conservatorships on what's now a relatively small claim. Conservatorship is, appointing a guardian, a protector, someone to manage the personal and financial affairs of another person, usually a child in a case like this. And current law is, no child can receive $5,000 without having this conservatorship in place. And that could be scholarship, or if you have a child actor, it could be wages, and yes, it could be lawsuits and settlements as well. But conservatorships are pretty cumbersome and they can be costly to the families too. So I did one recently in a pro bono case. It's $160 for the filing fee alone. And then if I was billing for attorney fees, which I wasn't, it would have been 2 to 3 hours of time to get the paperwork together and notarized. And then there is an annual reporting that the conservatorships have, which if it's a case involving a baby, could be 17 years of reporting to the court annually of, I didn't do anything with the money, I didn't spend it on anything. So it's a pretty cumbersome process. 25,000 amount seems reasonable on a couple of levels. We still want to protect minors and their assets and their interests, but without having too much paperwork to the courts or costs and fees associated with that. 25 is also the minimum amount of insurance coverage in the state of Wyoming, so it should capture if there are smaller car accident claims involving families and kids, it can cover that amount. So it's a nice bill in terms of making things a little easier, a little less paperwork, a little less costly for people who find themselves in these situations. And if we can trust parents to feed and clothe and shelter and raise their children, we can trust them with a certain amount of assets. And then if the claim is big and it's more substantial money, still conservatorship, still court approval, and still the protection that minors deserve. So a good bill.
Questions, committee? My only question is, in my career, which is still pretty young, I've only done one of these where I had to build a conservatorship for a wrongful death claim. How common is it in Wyoming? Can you put your thumb on how many of these we see approximately across the state in a year?
Overall, no. I have multiple pro bono cases going on right now. So one involved a family coming back from a lacrosse tournament with other children in the car. So I got 4 children in just that one, and then another car accident involving a child pedestrian in Hot Springs County. So I have 5 going just by myself right now. I bet it's dozens, if not hundreds, scattered around the state for anything involving a kid.
Okay. Well, you're beating my record very clearly. Just one case. All right, thanks.
Okay, thank you, Mr. Chairman.
Other public comment? None in the room. How about online? Not on this bill. All right, I'll close public comment. It's been moved by Senator Hicks. Is there any discussion or amendments to this bill?
Mr. Chairman?
Yes, Senator Hicks.
This would pertain to the last bill too, that just thinking about this inflationary component, and understand that some of the people in our legal profession are not mathematicians, but there is a way that we can do in statutes where we have to review those, and that's put sunset dates on it. And so the staff does capture those. They send out every year, but and I understand, but it's just if we were inclined to say, look, we need to really start looking at these, you set a sunset date and the legislative body is gonna have to come back and take a look at that. Because some of these do go on for decades and then they become cost infeasible to implement. But that's just a suggestion. I'm not moving an amendment now, but for this committee to think about how, or if that was even applicable for this circumstance or any of these circumstances.
Mr. Chairman,
Senator Crum?
you know, in visiting with Senator Crago, there is another protection for that settlement amount, and that's the attorney involved. They have an ethical duty to make sure things are somewhat reasonable too, so there is protection in there from the legal side on the settlement part too. So I'm comfortable with that.
Okay, all right. Pierre, will you please do a roll call vote on Senate File 10?
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson,
Aye.
5 ayes.
Anybody want it, other than Senator Craig?
Well, I can
You want it, Senator Cole? All right, we'll back you up. We'll be there for you.
Probably need it, and I do disagree that lawyers can add very well.
Ah.
My bills reflect that.
Yeah, the lawyer can add the billable hour really well.
Yeah,
Yeah.
that's not, doesn't
That's
seem to be
not
a
a
problem,
problem.
Mr. Chairman.
All right, the last bill we have for our consideration today is Senate Joint Resolution 1, Convention of States. Chairman Barlow. I took the big room expecting it to be packed for this bill, and it usually is.
Thank you, Mr.
You
Chairman.
flew under the radar.
I think, Mr. Chairman, I think it was where it was on the list.
Oh.
It might have go overlooked a little bit, even by me, until not long ago. Thanks to Senator Hicks for reminding me. Mr. Chairman, members of the committee, there are folks online though,
Okay.
Mr. Chairman. I think Peter has at least a couple, so. Thank you, Mr. Chairman. I'm pleased to present to you Senate Joint Resolution 1, Convention of States. Many of you have been through this process and understand the issue. Certainly Article 5 of the US Constitution is the starting point in this process. And Senator Crum is certainly new to the legislature, but we've actually visited a little bit and he's kind of got some background on it. So I hope we can move quickly through this and get to some of the testimony. This is the exact resolution that the former members of this body have seen before and considered before. And as you know, Article 5 has two ways to amend the US Constitution, either a proposal from Congress or the several legislatures can make application, go through a convention for amending the Constitution, not rewriting, amending the Constitution, and then subsequently send it back to the states for ratification. Congress only has two roles in this, as you well know. One, calling the convention when they see the adequate number of applications, which is 2/3, which in our current 50-state republic, that's 34. And then setting the Congress then, after the convention, sets the ratification, whether it's by how the states are to ratify it. So those are the only two roles that the Congress has in this process. The rest of the process is to the several states. The 2/3 plus states, and then the 3/4 states to do the final ratification of the amendment. I'd be glad to walk through the bill, walk through the resolution if you'd like, Mr. Chairman, or if you just want to go straight to questions, however you'd like to do it. Like I said, four of my colleagues up there have seen this before, one I've visited with, so I don't want to take your time when there's other people to testify, and we're the last bill of your day, so your preference, Mr. Chairman.
You don't have to walk through line by line, but if you don't mind giving us a quick walkthrough, that would be helpful.
I will, and I'm going to skip the whereases, because whereases are, they're statements of, we think this, but let's get to the meat of the bill. So the meat of the bill is Section 1, page 2, line 16. And this is the legislature of Wyoming making application on 3 issues. I'll go to line 21, imposing fiscal restraints. There is nothing in the US Constitution that imposes fiscal restraints on the federal government. That is not the same with the Wyoming Constitution. As you know, Wyoming Constitution does have fiscal restraints within it, limiting the power and jurisdiction of the federal government. We, in this state, have had our fair share of what we believe are undue burdens through regulations, et cetera, from the federal government, impinging upon what many of us think are our sovereign state rights, whether it's about resource developments, et cetera, et cetera. And then the third thing that this particular resolution calls for is term limits on federal officers and members of Congress. And federal officers could be both the courts, and it could be employees of the government, if you will, public servants. So that would be something to be determined in a convention, however that convention, if that convention were called for that purpose. So that's section 1, is just the 3 purposes of this particular petition. And then the remainder of it is just process. It's about who does what, when, where. And as I said, Congress, the states make the application. When you get to 2/3, go to number 2. They call for the convention. The Congress calls for the convention. That's on the bottom of page 3. Go to page 4. This is and that requires the 2/3 again. And then the states actually establish the convention, the rules of the convention, the processes to be dealt with. And I think probably one of the most important things on page 4, in my mind, page 4, line 14 through 17, is the consideration that this is a republic, and each state will be equally represented in this convention. Thus, we will have a vote, just like any other state, of equivalence. That's the basis of where we are, and that's how a convention would be. And by this resolution, we are affirming that we will not participate. It's not in that republic form. Rest of page 4, excuse me, talks about the limitations. You'll hear there are folks that are concerned about runaways. The call from Congress, based on the application, is the limit of the topics. And while I know that folks can say, look, whenever a legislature or somebody convenes, they can do anything they want, the check on that is the states. The states say, come on home, delegates. You're not doing what you're supposed to. This convention is off the rails. Come on home. That's contained a little later, but that's one thing. The other thing that's the check is the ratification process, which requires 3/4, excuse me. So there are several checks in this, and Wyoming has already adopted the statutory structure for both appointing delegates and recalling them, should they, and actually has, I believe it's still felony provisions, and I apologize, I did not bring that statute with me, felony provisions for those who do not uphold their duty as a commissioner or a delegate to a convention. On to page 5, Mr. Chairman. On the top of page 5, I think is also something that needs to be pointed out in this particular, that the Bill of Rights, which is the first 10 amendments to the Constitution for Wyoming's application, are ineligible to be dealt with. We are not going to touch First Amendment, Second Amendment, Third Amendment, go down the line. And it would be out of order and not in the delegates' ability to consider anything that had to do with those first 10 amendments, the Bill of Rights. As you go further, this is page 5 through lines 5 through 11. This is where the Congress can determine the ratification process, and then there's 2 options in Article 5, and that's the legislatures or convention in the state. So that is one thing. We obviously, this resolution recommends the legislature, but Congress has that authority to either one. Romanet 7 is that recall and further instructions, and then the ability to discipline or remove those delegates from their duties, should they not. And then section 3 is just, this is an ongoing application, stays on the books until we get to 2/3. Currently, with this identical resolution. There are 19 states. I think it's being considered in 10 more states this year, Wyoming being one of those 10. And so we're getting very, I mean, with successes this year, we're getting closer. We're getting very close, and I'm very confident. Wyoming does have a balanced budget, one that some of you were involved in several years ago. So there can be a summing, if you will, if another one just had the term limits, and we have, I think, one of those on our Senate floor right now. It may be coming to your committee just for term limits. And there are, others that have term limits in them specifically. Congress would have to make that determination whether they can be aggregated. Term limits is term limits is term limits. And I think that, and like I said, that's a job for the Congress. Again, it's 2/3 of the states. And then the final, should we pass this through the Wyoming legislature, and then it would be transmitted to these folks. So with that, Mr. Chairman and members of the committee, I'd be glad to stand for any questions. There are folks of the organization. Well, this is called Convention of States. Convention of States is an organization that is advocating for this. This is an application to call for a convention. And it is not, it happens to be something they have kind of formatted and put together and are working, advocating for. But this is based on Article 5 of our U.S. Constitution, the same one that we, as new legislators, just took an oath to. Us that were in the middle of our term, we didn't take a reaffirming oath, but that's, and I'll say this about this. When I first came into the legislature, I didn't know, I didn't understand this. And I went to 4 different conferences in this country and sat down with legislators from all over the country, all different walks of life and different political leanings, et cetera, and other experts, constitutional scholars, et cetera, which I am not, and I know there's probably folks who are, but I am not. It's the plain reading. And when I looked at the plain reading after those 4 meetings, I was very comfortable with the process. Now, there are folks that advocate for other issues, right? Dark money, other things, Citizens United. There's other things. The size of the Supreme Court, we need to put that in the Constitution. There are other issues out there. I am most, and I'm not gonna say I'm agnostic about those. I care about each, have maybe different feelings about each one of those. This one has just these three, but I'm most confident in what the founders said in the Constitution and gave us this right, this ability. And this ability is incumbent on legislatures to take advantage of it on behalf of our citizens. And that's why this is before you today. Thank you, Mr. Chairman.
Questions for Senator Barlow? Senator Hicks?
Senator Barlow, you may have already stated it, but how many states have already passed resolutions or applications? So where are we at? I think you stated that, but I missed that. If you could repeat that.
Senator Barlow?
Thank you, Mr. Chairman. Thank you, Senator Hicks. 19 have adopted the identical one. And then, like I said, there's some others that you could, if Congress wanted to aggregate them, like for term limits, they could maybe have that conversation. But 19 of this particular format and these particular issues have been there. Last I heard a couple weeks ago, there was 10 states that would be introduced this year. Thank you, Mr. Chairman. 10 additional states, excuse me.
Senator Hicks, you good? Senator Crum?
Just a couple quick questions, Mr. Chairman. One is, when it says, you can call them home, who calls them home?
Senator Barlow?
Thank you, Mr. Chairman and Senator Crum. Our statutory structure, and again, I apologize, I'm confident our statutory structure says that the legislature names the delegates and sends them out, and they have the ability to recall them. So it'd be the Wyoming legislature either through special session for this purpose, and actually this is I'm sure this is one of the reasons we can call it special session is for this very purpose. And I apologize again to the committee that I don't have that right in front of me, but I'm confident in the legislation that it was then Representative Larson, and I think Senator Hicks ran legislation about 5 or 6 years ago that codified that process, cleaned it up, and I think modernized it to what we would expect now and understand now. And it's the legislature. This is not an executive branch function. This is not a judicial function. This is the legislature of Wyoming as a representing as a part of this process. And that's why you will note So if we pass this, it does, I'm confident it doesn't even need a governor's signature. This is our action. This is the legislature's action, not an action that requires a signature of a governor. Thank you, Mr. Chairman.
Mr. Chairman?
Senator Crum?
And then just a quick follow-up on that too. So as I understand it, it takes 2/3 of the states to ratify something, then it comes back to the states. It needs 3/4 to approve it. If there was something that was not in the best interest of Wyoming, could we withhold our delegation so it didn't get to the 2/3 even at the site?
Senator Barlow?
Thank you, Mr. Chairman. So I just want to clarify. The application requires 2/3 of the state. So the whatever it is, balanced budget, 2/3 of the state have to ask for that. And then as the convention convenes, they come forth with an amendment to the Constitution, again, an amendment to the Constitution regarding that issue that is agreed upon by those that 2/3 of the states that, not 2/3 that participate, 2/3 of the states. You know, if it's 37 states show up and 3 of them vote against it, it's still going to go to Congress, and Congress will say, yep, go out, and the states get, now it takes 3/4 of the states to ratify. We're at 38 states. So the key to this is 13 states can stop any resolution or any amendment to the Constitution. So that, I think, is the protection that we have, is even in these times when we're, you know, we color code ourselves and we do other things, it takes, you know, a super minority to stop something that is untoward, that would be damaging. And notwithstanding the fact that First through 10th Amendment are not even on the board. They're not even, can't even be considered. So with that, Mr. Chairman, I'd be glad to stand for further questions.
Senator Crum, anything else? All right. Thank you,
Thank
Senator
Mr.
Barlow.
Chairman.
We'll go to the room. Anyone wishing to give public testimony on this bill? Mr. Downing.
Thank you, Mr. Chairman. Jonathan Downing on behalf of Convention of States, and we have a couple of my colleagues online that will be prepared to testify. If you need any questions after that, I'll be available.
Okay, great. Anyone else in the room? Ms. Herman, and then Mr. Moline.
Thank you, Mr. Chairman, Committee. I'm here in a minority position, I would probably acknowledge coming forward. But anyway, Marguerite Herman for the League of Women Voters. I'm a lobbyist for the Wyoming League, but what I will express today is a position taken by our National League, and it was formalized in 2016. And so, and it's been updated and affirmed since then. And so even though what I'm going to describe is our National League position, I will be happy to defend it and follow up questions if you want to. So the League has opposed this method of amending the Constitution, has never been for it, prefers the method where Congress puts out a proposed amendment to the states and gets ratified that way. And I'll go further explain that. To start out with, there are no rules and guidelines in the US Constitution on how a convention would work, which creates an opportunity for runaway convention that could rewrite any constitutional right of protection currently available to American citizens. As we all recall, the last time this happened was in 1787, and the outcome was great, but I guess it's the fear that with that kind of a situation, are we sure of that? Are we 100% sure of it? An Article 5 convention is a dangerous threat to the US Constitution, our democracy, and our civil rights and liberties. There is no language in the US Constitution to limit the convention to one issue, regardless of the best intentions of Wyoming, and we could put whatever we want out there and say this is it, or these 3 issues, but that's an expression of desire. It's not controlling really what the convention can do. And once convention to one issue, and there is reason to fear the convention, once called, will be able to consider any amendments to the Constitution that the delegates want to consider. There are also no guidelines or rules to govern the convention. Due to the lack of provisions in the Constitution and lack of historical precedent, it is, 1, unknown how delegates to a convention would be picked. 2, what rules would be in place. 3, what would happen in the case of legal disputes. 4, what issues would be raised, so on, how the American people would be represented, and how to limit the influence of special interests in a convention. And I'll just go straight to, so what the league did is it came up with, if there is a constitutional convention, the league believes the following should be considered in identifying an appropriate, if there is going to be one, these would be, we suggest, appropriate and well-crafted constitutional amendment requirements or conditions. Let's see. The convention must be transparent and not conducted in secret. Representation at the convention must be based on population rather than one state, one vote, and delegates should be elected rather than appointed. And this is the idea that we've always been on the record for, is proportional representation, one person, one vote. This has always been the base. The league has always used that as a premise. Voting at the convention must be by delegate, not by state. The convention must be limited to a specific topic. Only one resolution, only state resolutions on a single only state resolutions on a single topic count when determining if a convention should be called. And what that means is that, we talked about 34 states. They would all have to agree on a topic, not just, yes, there should be a convention, and then they have their own personal list. And the validity of the state calls for Article 5 Constitutional Convention should be determined by the most recent action of the state. And those things would ameliorate the concern we have about the convention, those conditions. And it does differ greatly from the SJ1, which is before you. So we would suggest that this be defeated because it does not, in fact, meet those criteria. And if you, I'd be happy to answer any questions you want to follow up with.
Senator Crum?
Mr. Chairman, just a question, if I understood this right, the proportionality of the situation. If I did my math right, 1 out of 50, we've got a 2% vote right now.
Mr. Chairman.
But if we divide it into the population, we'll have, I don't even know how to do this in percentage, 16 10,000ths of a vote. So Wyoming basically has no say in the matter if it goes to convention of states, if we go to proportionality.
Well, Mr.
Ms.
Chairman,
Herman?
the idea is that this is being done by the people, not by the states. In other words, that as an individual in Wyoming, I guess just as much say as someone from Texas or someone from Nebraska, and the authority comes from the individual person. It doesn't come from the state. So I would be represented at the same level as others, and I don't know the percentages. I would trust that you've calculated correctly, but that it is an action that represents the desires of each individual citizen of the United States.
Thank you.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Just, so today we're talking about Senate Joint Resolution 1. So I would appreciate something that directly applies to this document that we could talk about, that you disagree with, line for line or section per section or whatever that may be. That'd be really helpful, Mr. Chairman.
Thank you, Senator Kolb. Ms. Herman?
So I would just simply respond that list of conditions that we would like to see in any proposal, the extent to which they are not present, would represent opposition to the proposal. The proportional representation is kind of thing it's a very basic tenet of my group. So the absence of that, as described, each state gets a representative. I mean, each state is equally, so the representation is by state equal, kind of like the US Senate. And that would be that would diverge from the basic qualities of the proposal. Which I know is not popular in Wyoming for a whole bunch of reasons nevertheless.
Senator Cole, please.
Yeah, thank you, Mr. Chairman. So you disagree with the Electoral College? I'm confused about what you're talking about. Could you clarify where you're at with that? Thank you, Mr. Chairman.
Ms. Sermon.
Happy to. The League of Women Voters in its endorsement of proportional representation does advocate for a national popular vote.
All right, effectively diverged from the topic. We're not going to get into national popular vote, so thank you, Ms. Herman. Mr. Moline.
Excuse me, Mr. Chairman, Brett Moline, Wyoming Farm Bureau Federation, sitting in support of this resolution. I think these are issues that we need to work on, and I think this is an appropriate mechanism to do it. I appreciate that it is based on representation by the state, and I believe this resolution has the safeguards in it that should the person from Wyoming or the people from Wyoming go, for lack of a better term, go rogue, that we would have a mechanism to make everything work the way it's supposed to, that if they go rogue, we don't sign off on what they do. And with that, Mr. Chairman, trying to be brief, I'm not very good at it, but I would sit for any questions you or the committee may have for me.
You were pretty brief. Questions from Mr. Moline? All right, thank you.
Thank you.
Any other testimony in the room? All right, I don't know if anything's changed online, but I have 4 participants signed up. You have Michael Ferris in the room? Okay. Welcome, Mr. Ferris.
Mr. Chairman, thank you so much. I hope I can be heard.
We can hear you, we can see you.
Okay, I'm going to change the light for sort of that little bar is not there. Mr. Chairman, members of the committee, thank you so much. I will try to be as brief as possible. Brief background, I am a constitutional lawyer. I've argued constitutional cases for most of the nearly 48 years I've been a lawyer. I've argued 2 in the Supreme Court. I've represented members of the Washington State Legislature in a constitutional challenge to the effort to extend the time for ratification of the Equal Rights Amendment back in the late 70s and early 80s. I'm one of the few lawyers in the country that's actually litigated an Article 5 case. I want to go to the last week of the Constitutional Convention very briefly to set some background. George Mason stood up on the floor of the Constitutional Convention and said, and I'm paraphrasing obviously, someday the federal government is going to abuse its authority. And when that happens, the method of proposing amendments where they can only come from Congress will never give us an amendment that will reduce federal power because it's against nature for somebody to vote to reduce their own power. We've got to give the states the power to reduce the power of the federal government. And that change to the process, which is the current form of Article 5, was agreed to without debate. They saw the good sense of giving the states the ability to limit the power of the federal government. And so, as you've heard, 19 states have adopted this exactly, and under the belief that the federal government is in fact abusing its authority, and the twin belief that legislatures have the moral responsibility to exercise the authority that's given to them by the Constitution of the United States to stop this kind of an abuse of power. So if you believe that the federal government spends dangerous amounts of money and the escalating national debt is a threat to our future, you should support this resolution. If you believe the federal agencies shouldn't be able to make law without going through Congress, you should support this resolution. I would just note that we have 5 times as many federal administrative laws as we do laws passed by Congress. If you believe that we shouldn't be subjected to international law by the signature of the president only, and we should send all treaties to the Senate for ratification, where currently only 2 out of every 100 treaties is sent to the Senate for ratification. Those are the kinds of things that you can fix with this amendment, with this process rather. Now, the only questions that usually arise in a conservative state like Wyoming, revolve around the claim the process will run away. And I want to deal with the first and most common argument in that regard that was brought up by the last speaker, and that is the myth that the 1787 Constitutional Convention in Philadelphia was a runaway. I've written what I consider to be, and many consider to be, the definitive article that's published in the Harvard Journal of Law and Public Policy that gives you the complete answer to this myth. The states called the convention. The directions to the delegates was to render the federal constitution adequate for the exigency of the Union. The argument that they were only supposed to amend the Articles of Confederation is a myth. And it came from a resolution passed by the Articles of Confederation Congress that simply gave their opinion as to what should be done at the convention. If you read the Articles of Confederation, there was no power in Congress to call such a convention. They didn't purport to call it, and nobody thought that they were. When the delegates looked at their authority, they looked at the resolutions coming from the states. I sent you all by email a few documents, including a 2-page summation of that Harvard Journal of Law and Public Policy article. But if you want the whole article, if you just Google my last name, Farris, which Farris, and then the words defying conventional wisdom, you can read the entire Harvard article online for free. There's no paywall. It's readily available to anyone. And I would just simply say, I think it's important for all of us to defend the integrity of the Constitution of the United States. Because if you say it was a runaway, what you're saying is illegally adopted. I just think that we should avoid ever saying the Constitution of the United States was illegally adopted. It denigrates our faith in the Constitution, and it's just historically not true. Secondly, I want to answer an argument that is commonly raised in many circles, especially conservative circles, that the convention could run away and would end up violating our rights. And I will use a common example in that we could lose our Second Amendment by this process. So I'm going to take that on head on. Now, there's a lot of reasons that wouldn't happen. It's not germane under the rules. It's not germane under the call. You can't change the rules in the middle of the stream. The ERA case that I litigated went to the Supreme Court, and it's been litigated in recent years under efforts to try to revive the ERA. The holding of every court has been you can't change the rules in the middle of the stream. So let's just pretend that they still get away with changing the rules in the middle of the stream, despite all that precedent and despite all the impossibility of doing that. And we're down to our last line of defense, and that is ratification. 38 states have to ratify any proposed amendment, no matter how it gets there. And if it's impossible, it's politically impossible to imagine a scenario where 38 states would ratify an amendment that curtails or eradicates Second Amendment rights. The number of states that have constitutional concealed carry provisions are well more than 13. I think it's about double that number. You can list off the states that would defeat such an amendment readily and get to around 30 really, really quickly that would defeat it. And it only takes one chamber in 13. So the political impossibility of that is simply so evident, I won't belabor the point. But I want to compare that to the status quo. Our Second Amendment rights were really only established clearly by the DC versus Heller case about 20 years ago. And that was by a 5-4 vote in the Supreme Court, because the contention was that it's only the militia that have the rights, which is basically the National Guard, and not an individual right. And the pro-Second Amendment forces won that by a 1-vote margin in the Supreme Court. So here's the scenario that could actually lead to the curtailment of our Second Amendment rights. You need an anti-Second Amendment president. You need a political party in control of both houses of Congress that's also anti-Second Amendment. In that scenario, the party in charge repeals the filibuster rule in the Senate, and then they move to expand the number of justices on the Supreme Court to whatever number they need to get a anti-Second Amendment majority in the court. And then they pack the court with enough Second Amendment justices, and one of their state attorney generals brings a gun case to the court, and bingo, our Second Amendment rights are gone. That is incredibly realistic and is foreseeable, I would suggest, in the next 10 years. But the resolution that's in front of you can completely stop this, because the power to limit the power and jurisdiction of the federal government in this convention would include the ability to take away the power of Congress to set the number of Supreme Court justices. So an amendment that establishes that 9 is the permanent number of the Supreme Court is germane under this resolution in front of you. So the very best defense to stop the court packing, which is the greatest threat to the Second Amendment, is right in front of you. If you want to do something to protect the Second Amendment against the very greatest scenario that we could imagine, which is all too realistic, what you got in front of you would stop the eradication of the Second Amendment better than anything else. I would finally like to close. I've sent you also by email evidence that the John Birch Society, that I know has been active in Wyoming opposing us, that they came before this legislature, that same organization came before this legislature in 1959 and asked this legislature to pass a resolution calling for a convention of the states to pass the Liberty Amendment. I won't go into the details of the Liberty Amendment. I'll just say amendment. I kind of like it. And Wyoming's legislature did call for a convention of states for that purpose. A number of states did at the time. I think it was in the 20s at the time. And now the John Birch Society tells us that doing this, it's too dangerous. Well, it's interesting. The John Birch Society has turned their back not only on the solution the founding fathers gave us, they turned their back on the solution that the founders of their own organization gave you. And I sent articles from the Sheridan Wyoming newspapers in the early 1960s that show you that the John Birch Society was in fact behind the Liberty Amendment, and I sent you the actual document of the Liberty Amendment itself, and this legislature's resolution calling for a convention of the states for that purpose. So the final point I would make just to answer the question about the existing Wyoming law, I do have the citation for that it tells all the rules for appointing delegates, controlling their actions. It's Wyoming's law, section 9-22-102. Yes.
Got you clocked at 10 minutes now. It's a bit.
Okay, I'm done. I just wanted to give you that citation and I'm done.
Okay, yeah, thank you. Why don't you wrap it up?
Okay, yeah, I just say that the law that gives you the limitations on delegates and how you appoint them is Wyoming statute 9-22-102. I'd be glad to answer any questions.
Questions from Mr. Ferris? All right, thank you for joining us, Mr. Ferris.
Thank you.
Who do we have next? Let's let Ms. Baker in.
It looks like I'm being called, is that correct?
Yes, Ms. Baker, we can hear you. We can't see you if you want to turn on your camera.
All right, I have this slider thing here. Okay.
Welcome.
Thank you very much. Good afternoon, Mr. Chairman and members of the committee. My name is Julie Baker. I live outside of Hewlett in Senate District 1, and I'm the state director for Convention of States. In order to respect your time, I know we're getting on a little bit. I'll give the cliff notes of my testimony. I just wanted to, on behalf of the thousands of supporters of Convention of States in Wyoming, respectfully ask you to vote yes on SJ1. Because you normally get supportive emails only from your district, you may not know that there are thousands of supporters in Wyoming, over 13,000. They've demonstrated their support by signing the Convention of States petition. And in fact, Wyoming has the second highest number of petition signers in the country per capita. Each time we speak with someone who has just signed the petition, they're stunned that Wyoming wasn't the first state to pass the Convention of States resolution. It's so obvious to them that we should do this. So let's just put our stake in the ground and join the 19 other states who have passed this application for the framers' most powerful, peaceful, legal, constitutional tool to restore meaningful and enduring limitations on the federal government. Mr. Ferris talked about all the process. If you have any questions for me about grassroots and support in Wyoming, I'm happy to do the best I can to answer them. Thank you very much.
Ms. Baker, I'm just curious if you know, out of those 19 states that have adopted this Convention of the States call application, how many of those were recent, just in the last year or so?
Oh, that's a good question. Not in the last year. I think maybe Nebraska might have been the last, but I don't remember what year that was. It might have been 20. I'm sorry, I don't remember the year. I apologize.
It's not a big deal. I was just curious how long we've been sitting at 19 or in that range.
It's been a couple of years, I think, at least for the 19 range.
Okay,
Close though in many states.
very good. Any questions for Ms. Baker? All right, thank you, Ms. Baker.
Thank you.
Eldon Stahl. Welcome, Mr. Stahl.
Hi, can you hear me?
We can hear you.
Okay, great. Well, Mr. Chairman, members of the committee, I'm Eldon Stahl from Evanston, Wyoming, and I'm opposed to SJ1. And I have a question. What's wrong with the Constitution? Because this resolution deals with changing it. And because proponents don't want to answer that, their lobbyists get, lobbying gets a lot like fishing. Use a hook and cover it with the right bait. But the co-founders of the Convention of States Project have admitted as much. At the 2021 Freedom Fest, Mark Meckler was asked why, if there was no risk to a convention going rogue, why the resolution even has the 3 subjects listed instead of applying for a general or unlimited convention. And he said, quote, "The reason is for narrative. If I were to say, we're just going to have a convention, we have no idea what we're going to talk about at this convention, then frankly, nobody would support it because there'd be so much fear out there that we had to frame it in a way. And if you don't frame a political discussion in the correct way, you lose," end quote. So if they admitted the truth that they have no idea, as he said, what would come out of a convention, nobody would support it, as he admitted. The 3 subjects do not guarantee a limited convention. They are there for controlling or framing how people think about the argument, or getting people to accept a story or narrative. Michael Ferris, the other COS co-founder, explained it this way in 2013. Quote, "The greatest thing we can achieve out of a convention is if they mess it up again, we call another convention," end quote. Call another convention? That's the greatest achievement for COS? No specific change, just endless change? Is that what you want? Well, if you take the bait, you get the hook. Why did the founders write Article 5? Well, to provide a process for changing the U.S. Constitution under specific circumstances. Like what? Well, Madison said that it was to supply, or correct in modern English, defects. Washington said if the people feel the distribution of power in the Constitution is wrong, we could change it. Even George Mason, the revered father of the Article 5 Convention, said that the Constitution would be defective and amendments would be necessary. We hear about too much federal spending, debt, power, corruption, and so on. So, which parts of the Constitution gave us those problems? Surely the proponents can tell us. Or we could be honest with ourselves and admit that these calamities are from people ignoring, twisting, and trampling the Constitution. Am I wrong? Yet sadly, the solution in this resolution is endlessly changing the Constitution. That's called revolution. So in short, amending the Constitution is emphatically the wrong tool for these problems. But worse yet, the goal of its national promoters, perpetual constitutional change, as has been admitted, is being concealed by a carefully crafted narrative. So please oppose SJ1, and I'm happy to take questions. Thank you.
Committee, any questions for Mr. Stahl? All right. Mr. Stahl, you might not know this about me, but I'm from Evanston, Wyoming, so go Red
Oh,
Devils.
great.
Yep,
Well, it's a good place to be from.
yep, happy to see another person from Evanston on the line, thanks.
You bet.
And then do we have Mr. Hunter?
Yes, you have Mr. Hunter, I think. Can you hear me?
We can hear you, we just can't see you if you want to turn on your mic.
Well,
Or you don't, and it's up to you.
I'm not sure you want to see me, but good afternoon, Mr. Chairman and members of the committee. I am trying to press a little button for my video and it is not complying with me. So what I wanted to say was that if Wyoming wanted to put its money where its mouth was, if you actually look at the Constitution and the Electoral College and things like that, and as well as term limits, one of the best things that we could do is to go back and act like we repealed the 17th Amendment. We could give the governor and the state senate the power to appoint senators. That would make sure that we would have more term limits in the Senate, and also might increase the power. Again, I think the 17th Amendment robbed the state's power. It allowed more outside money to come in and influence who gets elected to the Senate. So I don't approve of going to do this, but if we wanted to set an example for the rest of the states to enhance our republic, we should put in legislation where the governor picks the Senate, each of the 4 years that if they get elected. So that would really, really do a lot for enhancing the republic and the potential for impeachment. I do think all that was robbed when we became a popular election of Senate, and it kind of wrecked the Electoral College. So that's my testimony on it, and good luck with your deliberations. I'll stand for questions.
Any questions for Mr. Hunter? All right, thank you, Mr. Hunter. Anyone else online? Anyone else in the room? All right, we're closing public comment.
Move the resolution.
It's been moved by Senator Hicks. Is there any discussion on this resolution? Any
Mr.
amendments?
Chairman?
Yes.
Well, I still have some reservations about this. I'm going to be for be an aye when we vote, because I do believe something this large should be debated on the floor of the Senate and not just by 5 people.
Any other discussion? Senator Barlow, did you have anything else? You're just ready. Okay. All right. Will you please do a roll call vote on Senate Joint Resolution 1?
Senator Crago,
Aye.
Senator Crum,
Aye.
Senator Hicks,
Aye.
Senator Kolb,
Aye.
Chairman Olson,
Aye.
5 ayes.
Well, there you have it, Chairman Barlow. Yep, thank you. With that, folks, we made it through all 4 bills. I guess I could have had a 5th one.
No.
Oh, okay. All right, we are adjourned.